Good afternoon, everybody. Hello, everybody on the webinar. Today we are talking about industrial manslaughter and the right to disconnect. And actually, this is the importance of grammar. That shouldn't actually be "and" the right. It should be full stop and then the right to disconnect, because we don't want to disconnect from industrial manslaughter risks. Hence, my talk today is really about the introduction of the Industrial Manslaughter Bill, which will be an amendment to the Work Health Safety Act. As at last Friday, it went before the Parliament for the second reading, and my research since then suggests that it's been adjourned, so I'm not really sure what the status is at present, but I think we can be guaranteed that it will pass probably in the form that it is now, and I note that since the original draft, there has been a slight amendment. Tammy Franks has snuck through an extra $5 million added to the penalties, so we'll now be looking at maximum $18 million for a corporation. The background to it obviously was, I think, prompted largely by the fatalities at the RA during the construction period, and also clearly there's been quite a few unfortunate fatalities along the way since then, and obviously prior. And also to bring SA in line with most of the other states, which now have a specific industrial manslaughter law, as opposed to a general manslaughter law that we have in the criminal code. One of the criticism, I guess, that I think the Liberals in particular were, and even the Law Society, were directing towards government on this one was that we already have manslaughter laws, so why include or introduce a new one? Because the existing laws should be capable of dealing with serious consequences from workplace activities, just as any other untoward and unintentional death might be. However, the government has been pressured fairly highly by the unions and some advocacy groups, and it also came to, it was elected on one of these, this was one of its election platforms, so it will go through with it. So what does it all mean? What it means, you can read it, that's good, is that we're going to get an extra category added to the Work Health Safety Act. At present we have 3 categories, ranging from obviously the most serious, where there could be a risk of death or serious injury, right down to just a standard breach of a safety obligation and duty. So the proposed bill will now introduce the concept of industrial manslaughter, which will mean that if a person conducting a business or undertaking, a PCBU, a business, an entity of some form, or one of its officers commits so what they've basically said is that you're going to commit industrial manslaughter if you have a health and safety duty. That's pretty basic. Every PCB will have one, and every officer will have one. And you breach that duty. And, so these are ors, and the conduct that the PCBU or person has engaged in causes the death of an individual. So it's not a risk of death, it's causing a death. And because of that, it's found, and this has got to be proved of course, that the person has been reckless or grossly negligent. Or, and this is the first or we get, they are reckless as to the risk that an individual could have died or suffered serious injury and subsequently dies from those injuries. So it's a pretty high test, it's a high bar, on the basis that we are dealing with criminal offences here, so it's to be proven beyond reasonable doubt by the prosecution. And the prosecution in this case will be Safe Work SA. So that's the new law to be introduced. We then have to find out, what does grossly negligent mean? We know what reckless means. And they've actually been kind enough to give us a definition. So the definition is this: a person is guilty of gross negligence as to the risk of an individual of death if the person, I can't even read that myself. What's it say? The person's conduct, yes. Involves such a great failing or falling short of the standard of care that a reasonable person would exercise in the circumstances. So it really has to be, blatant negligence to the point where, blind Freddie would know that you shouldn't have done what you did, or you should have done something that you didn't do. And secondly, that there was a high risk of causing death of an individual because of those actions, and as such it would merit the most serious of criminal sanctions other than murder. So it's a pretty high test, and ultimately if there is a finding of guilt, the penalties are very significant. So for an individual, up to 20 years in prison, and for a body corporate, up to $18 million in fines. And obviously convictions recorded. Now, if this matter goes before the court and it's either a judge or a jury, it won't be a magistrate because the penalties are too high for the magistrates to impose. So it'll have to be for a judge. It will still be at the CSA tribunal, employment tribunal, but one of the deputy president judges will have to sit on these matters. If the judge can't come to a ruling that the charge has been made out, they will have the option to then look at category 1, 2 or 3 that currently exist and convict the person or the business and the business of one of those lesser offences. So it's not a, you succeed on defending, or I should say the prosecution doesn't succeed on prosecuting the offence, and then you walk free. The arbiter then has the choice to look at the various other offences under the Act and see if you fall within one of those, and obviously I think that the answer would be yes, you would. So this is the existing law as we have it. So category 1 at the moment, and so the industrial manslaughter will fall above that in the Act. It'll be section 30A, and then beyond that we'll have the further categories that we already have under the Act. So at the moment, the most serious being negligent or reckless conduct that exposes a person to risk of death or serious injury. So we don't need to have a death, just exposure to. So that could be an obvious second step down if manslaughter can't be proven. And then we fall back to the corporate penalty of up to $3 million and an individual up to 5 years in jail. And then we have the category 2, whereby you're exposing a person to a risk of death or serious illness or injury, with the lower penalties again, 1.5 million, and there's no prison sentence involved in that one. And then category 3, which is our run-of-the-mill, most common charge brought against corporations or individuals, rarely, with a maximum of 500,000. Now, importantly, also industrial manslaughter laws will not be subject to the usual 2-year statutory limitation. So at the moment, charges brought under the Work Health Safety Act have to be brought within 2 years. If they're not, then the prosecution would have to seek ministerial authorisation to issue beyond the 2-year period. Hence, I'm not sure so much at the moment, but in the past we used to get summonses issued on the last day of the 2-year period. So it will avoid that. rush by the prosecution, and it will keep open the risk to a business or person indefinitely, essentially. I think also the reason for that extension is that someone, and the Act, or the bill, specifically deals with this, may die as a consequence of an injury or an illness beyond the 2-year period. So we're talking about dust diseases and exposure to silicon, etc., which is the hot topic at the moment. So it could well be that that was the intention. So, which leaves it very broadly open for charges to be brought many, many years after an alleged grossly negligent or reckless act. And furthermore, no enforceable undertakings will be available. So presently under the Act, a business may seek, in the alternative, to be prosecuted, to enter into an enforceable undertaking, and that could be spending a significant amount of money on safety improvements, on education, publishing in industry magazines what's happened and how they fixed it, that sort of thing. That won't be available. Just as an example of how similar laws have been applied interstate in recent times, in Queensland they have a very similar test. It's one of negligence, not gross negligence, and with penalties of maximum 20 years and up to $10 million fine for a company. And in Western Australia, they have what seems to be a knowledge test, that is that the prosecution must prove that the accused actually had knowledge that their conduct is likely to cause death or serious harm, and then have disregard of that knowledge. In other words, be reckless about it. So probably a harder test for the prosecution to prove in Western Australia. In Queensland, there were a couple of cases. One involved the Brisbane Auto Recycling Company. Unfortunately, a worker was killed by a reversing forklift in the factory. The driver of the forklift was inexperienced and unlicensed, and the owners and operators of the business, and the directors in particular, were aware of that fact, and they were aware that there was a danger with the forklift operating within the factory when people were not appropriately protected from being hit by it. The business didn't have in place that little checklist there on the right. I won't go through it all, but essentially they really didn't have any health and safety policies at all. They didn't have any safe work procedures. Their attitude towards health and safety was to tell the workers, be safe and look after yourself. Now, clearly that did not come up to the standard required under any person's interpretation of a duty of care. And as a consequence, the worker died 8 days after being struck, and the directors were found to be reckless, with no regard to the risks that they were actually aware of, and with no risk control or assessments in place, and in the context of an extended period of offending. So they were imprisoned, they received a 10-month imprisonment, which was then suspended for 20 months. So essentially they didn't go into prison, but they were under the risk of going to prison for the next 20 months. The company itself was fined $3 million. In the matter of Owen, unfortunately, this involved Mr. Owen's good friend, Mr. Orms, and who had essentially just volunteered to help him out at his factory. A couple of mates doing a bit of work on the weekend, I believe, and Mr. Owen was driving the forklift. He wasn't licensed. He picked up a very heavy generator, and the generator was unstable on the tines of the fork, and his friend Mr. Orms was in front of the forklift, and the generator fell on him and killed him. Owens was obviously distraught and very remorse about this, pleaded guilty, but it was, and hence he was convicted of gross negligence. He didn't have a safety plan in place. He had knowledge that the forklift was not suitable for the task, but used it anyway. He wasn't licensed. And he continued operating the forklift even though he could see that the generator was not firmly secured and was rocking and potentially was going to fall, which it did. He was imprisoned. He was given a head sentence of 5 years in prison, which was quite serious, and that was suspended to 18 months. So still a significant penalty, and one really arising out of a unfortunate accident, but was very foreseeable. In Western Australia, it's the case against empty sheds. They were building a very large shed on a farm, and a couple of very young workers were on the roof of the shed. They weren't harnessed. A very strong wind gust uplifted a couple of the sheets of iron on the roof upon which the young guys were standing. One fell 9 metres to the ground and died. The other fell 7 metres and was very seriously injured. The company itself was found guilty and fined $550,000, and the owner of the company, or director of the company, was sentenced to 3.5 years, and that was reduced to 2 years and 2 months because he pleaded guilty early, and he had 8 months in prison, and the further 12 months was suspended. So the courts take it seriously. They're not imposing massive imprisonments at this stage, but I'm sure it will get to that point. So just finally, not teaching how to suck eggs. I'm sure most of you are very up with your requirements as far as due diligence and work health safety obligations, but just in summary, it's obviously clear that your directors and officers and senior managers need to be aware of this new law and the risk involved. And this is also important if you've got operations in other states as well, because the board might be sitting here, or they might be based in Queensland or New South Wales or wherever. But if something happens in South Australia, they're ultimately going to be responsible. And likewise, if you've got operations in other states and something happens there, the directors and officers could be responsible for what happens over there. So it's not something to be taken lightly, and clearly from the top down we need to have all the work health safety policies, procedures and systems of work in place, and not just in place but also regularly checked and updated if need be, keeping up to date with hazards. For example, the silica hazard has more recently arisen, whereas previously everyone thought it was just asbestos. Induction, obviously, right from the start of any employment, proper induction, proper training, and also revisiting that training on a periodical basis to ensure that employees don't get complacent. And if something does go awry, keeping really good records, because that's your best friend when it comes to defending a prosecution, and a lawyer's best friend if the client has a really good set of records and policies and procedures that we can point to, then you're on your way to being in a good position to defend a prosecution if it arises. Okay, any questions?
Got one question from an online attendee, which I'll put to you straight away. It comes from Harding L. The question is, can a PCBU or officer be prosecuted retrospectively after the legislation is passed and enacted? In other words, can they go back to former cases, category 1s, with new evidence or other way and retrospectively prosecute?
I believe not. It's the law will be in place when it's in place, and it will operate from that date on. So, especially, and you can't be prosecuted twice for the same thing. But if an incident has occurred in the past and charges haven't been laid, I'd still say no. I mean, unless that that inquiry has someone who's died in the last year or two at work, then I wouldn't be concerned. But I'm pretty sure it's not going to act retrospectively. It'll be a prospective.
Whether this is just a general inquiry or something that Neville might want to speak to the person who's directly sent me this message to. If you have any further queries, just email Neville, or you've got his contact details. Please visit our websites or have a look at the online packs that will be made available after this seminar. Any other questions from our online or in-person attendees? Give me 2 seconds. Oh.
Thanks for that. So I noticed we've got grossly negligent, and then Queensland's got negligent, and then WA's got something else.
Yep.
So what's the difference between grossly negligent and negligent?
One's worse than the other.
Yeah, well.
It's bigger. It's the wording that the SA, the drafter of the bill has chosen.
Yeah.
And I think if we look at the definition, one can be negligent without really being, overly negligent, I guess is the query. The idea, the wording here, and my interpretation is that they've defined it to be such a great failing that, your average person on the street would have known, okay? So it's not just negligent within your knowledge of the industry or within that particular workplace. A reasonable person can get off the bus, walk into your workplace and say, that's unsafe, So it's really that level. It's a very, very high test. Yeah.
So it's sort of the pub test.
Yeah, pretty much, without the beer.
Yeah. I also noticed that you mentioned enforceable undertakings. I'm pretty sure Cat 1, you can't have enforceable undertakings as well.
I believe that's the case, yeah.
Yeah. So I mentioned that for people in case they didn't know that.
Okay, thanks. All right, thank you.
Hi everyone, my name's Tilly. I'm a solicitor at KJK. If you've seen emails from me, it probably says Matilda, but I go by Tilly in the office, so if you're a bit confused. So have you ever found yourself laying in bed at night and reading your work emails, or having dinner with your family and a colleague or your boss rings and you feel guilty about you've got to answer it? Or have you ever felt guilty for leaving the office early or switching off your computer at the end of the day because there's probably a little bit more you could do, but you've got to get home? This is a very common thing. Overworking and unpaid overtime is a significant problem in Australia at the moment. In 2020, a mid-pandemic survey found that Australians were working 5.3 hours of overtime on average per week, more than previously. Unsurprisingly, this trend has continued even though the pandemic's sort of become normal. With hybrid working arrangements, workers are reporting a greater tendency to work during periods of illness as well, or injury, rather than taking their sick leave. So I'll be talking today about the Fair Work Amendment Right to Disconnect Bill that's just been introduced. It is a private member's bill introduced by Adam Brandt, the member of the Australian Greens Party. The bill stems from recommendations made in the Senate's Select Committee on Work and Care's final report, which is interestingly released on the 9th of March this year. The legislating the right to disconnect was one of the 30 recommendations made by the committee in their report. Some other recommendations include reviewing the 38-hour work week, trialling a 4-day work week in diverse sectors and geographical locations, and increasing the annual reporting requirements for the Fair Work Commission with respect to rostering and flexible work arrangements. So what does the bill say? The bill creates a legal right for employees to disconnect when they are outside of work hours. The bill proposes to make the right to disconnect a minimum employment standard under the National Employment Standards. If the bill passes, it will mean that employers cannot contact employees or require them to be contactable in outside of work hours, except in an emergency, for a genuine welfare reason, or if they are a recipient of availability allowance. Employees will also not be required to read, monitor, or respond to any type of communication outside of work hours, which of course we all likely do. Employees will also, availability allowances will mean an allowance for being rostered or otherwise directed by an employer to remain available to perform work during a period of time. However, you might say, what constitutes an emergency, Tilly? Well, this has not been defined in the bill as of yet. However, I consider the definition of an emergency to be, will likely be incorporated if it actually passes. But at this stage, we consider an emergency to be determined based on the circumstances. Contacting an employee during a pandemic or a natural disaster for help is probably an emergency. However, sending an email to an employee to ensure they urgently book time in their diary for a strategic planning meeting next month is probably not an emergency. What constitutes a welfare matter? Well, once again, the definition's not provided. However, it's probably on a case-by-case basis. Calling an employee who was involved in a work accident the day before to check on how they're going is probably a genuine welfare. If you're calling an employee while they're on leave to see how they're going and ask them if they've prepared that brief that you wanted last week, probably not a genuine welfare matter. The bill aims to address the phenomenon known as availability creep. But what is availability creep? It's a term used to describe the increased encroachment of our work lives into our personal lives. It's a pressure felt by employers to constantly be available to perform their work duties at any time. This may be reading a work email, accepting a calendar invite, etc., etc. Availability creep has been facilitated by the increased availability and need for technology. And why does it matter? Availability creep increases the risk of employees working overtime, which not impacts impacts the physical, mental, and financial health of the employees, but it also affects the business. What are the signs that it's infecting your employees? One of the biggest signs of availability creep is burnout. We've heard all about it. However, some of the other common signs include employees being irritated, grumpy, stressed, or even scatterbrained, decreases in productivity and performance, communication being sent out or addressed at all hours of the morning or night, increased absenteeism, and usually those who feel like their boundaries have been crossed are more likely to cross other people's boundaries in terms of availability. The right to disconnect is also a global trend that has been recognised as an issue and implemented in laws to protect workers in lots of other countries around the world. Some of these countries include France, Italy, Spain, and Belgium. These particularly one country that was ahead of its time is France. In 2017, introduced laws that prevent work encroaching on personal lives of employees by way of digital devices. Companies of 50 or more in France are required to negotiate with employee representatives and unions to determine when is the most appropriate time for employees to disconnect from their technology after work. They also include provisions that make it illegal for employers to take adverse action against employees who disconnect at that time. One example here in Australia is the Victorian Police. The right to disconnect has been part of the Victorian Police Force Enterprise Bargaining Agreement. The aim of including this clause was to encourage a culture shift within the Victorian Police where members could switch off after clocking off to improve the mental health of officers overall. The clause covers police recruits right from the recruits to senior sergeants. The EBA says that police cannot be contacted outside of hours unless it's an emergency or a genuine welfare matter or if they're being paid the allowance. An availability allowance was built into that EBA, which should be paid every hour outside of the normal working hours that officers are required to be contactable. This allowance is between $6,000 and $11,000 per year, depending on the officer's ranking. So it's quite a lot. So what can you do as an employer to accommodate the right to disconnect? Although this bill may not have passed yet, it's a timely reminder for all employers to seriously consider the impact the overworking and the lack of work-life balance can have on their employees' health and well-being, and take serious action to prevent availability creep from becoming an organisational norm. Some simple ways this can be done is conducting thorough risk assessments, specifically looking at the hybrid and remote working, the way that your employees use their technology, and the organisation's routine communication methods. Also creating clear policies around appropriate communication out of hours, work out your general what is considered normal work hours, and use of organisation supplied technology. Particularly as leaders in your organisations, you should act as role models as well for your employees when it comes to embracing the work-life balance. They will follow in your lead. Conduct education and training with your leaders about boundaries. And lastly, utilising technology for good, not evil. I know some of you already do this, but insert a small sentence at the bottom of your email signature which gives the recipient permission not to respond straight away, to respond when they're back at work, or create lockout periods whereby employees can't send emails or communications or can't even access the devices outside of hours. And at our last seminar, just moving on to something very briefly, at our last seminar we had a few questions about family and domestic violence leave entitlements. And so I thought we'd just do a little quick update that already in effect employees for non-small employers can access 10 days of paid family leave now. This includes part-time and casual employees, and employees from small businesses can access it from 1 August, so it's coming up really soon. Until then, they can obviously take their unpaid leave. And there are definitions for what is considered domestic violence. It's violent, threatening or other abusive behaviour by certain individuals known to an employee that both seek to coerce or control the employee or cause harm or fear. So in terms of getting evidence about whether the domestic violence leave is warranted, we recommend getting a medical certificate from a doctor or from a psychologist that supports that leave. And obviously it has to be in the pay slip, it has to be very incognito, so it can't be seen that that's what the type of leave they're taking. So we recommend having a code, maybe special leave or something that it comes under that isn't quite as blatantly obvious as domestic violence leave in a pay slip. That is something that's a bit of an administrative question. And that is everything. Any questions?
Peter Stiles from APRA, but in my other roles that I've held, it will often be in your contract of employment, particularly if you're not covered by an industrial instrument, that says you are required to work reasonable hours beyond the NES standard. It's all wrapped into your package. The real question in my mind is, well, what would happen to clauses like that, where the employer and the employee, would regularly understand and I'm thinking particularly, supervisory people in manufacturing sites, that'll be there for, not for the day, but, afternoon shift comes in and something goes wrong. Right?
That's right. Yeah, it's going to be an interesting scenario.
It doesn't seem to want
situation.
to take that into account.
No, yeah.
Tilly, can you just repeat part of that question? I don't think our online listeners were able to hear that. I'm not sure whether that microphone was on or if it was close enough.
Oh, how's that? Yeah, yeah. So the question I'm asking is, a lot of particularly white-collar contracts will say in there, incorporated in your remuneration is the requirement to work reasonable hours outside your standard hours, something to that effect. The question that doesn't seem to be even contemplated in this proposed bill or in the other jurisdictions is that, where does a clause like that say? Because, employers might say, well, if that bill passes, okay, well, I'll take 5% out of the remuneration package now because I can't enforce that contractual obligation.
Or it gets built in as a availability allowance, a certain amount is built in.
Could be,
For
but
the
it's
purpose
generally
of
not, because it's just all wrapped up in your REM.
Yeah.
Right? You're on, 105,000 supervisor. Mate, when we need you, we need you. Right?
Yeah.
You got to come in and help. And there's a few people here. Newspapers would be a classic place. Airlines are another place.
That's right.
Where you're called in certain situations.
It's going to create some issues so I don't think that's been totally fleshed out as of yet. But some places do. 4 hours of overtime, you get some built into your contract. That's part of it. Anything outside of that, but also where do you draw the line? I think it's very complicated. But should it pass, that will all definitely need to be fleshed out a lot more, and I'm not quite sure how that will be dealt with at this stage. But yeah, good question. Or yeah, may not even be an issue. That's right. Anything else?